Good morning. Yet another new concept, new issues raised before Supreme Court. All should understand this concept as well as this ratio. If you are interested in conducting criminal cases and you are a public prosecutor and you are aspiring public prosecutor, you are law student. This judgment is AR 2015, AR 2026, 2014, page number 2014. Syed Shanivas Ali versus State of Madhya Pradesh. Actually, what had happened, the father of the Shanavas Ali seems to have filed an FIR under section 156 class 3 against 4 accused. For that was accepted. The FIR was directed to be registered and the FIR was registered under section 419, 420, 467, 408, 471, 120B and 34 of Indian Penal Code. However, the additional session judge discharged all the accused for all the offences: 419, cheating by impersonation; 467, fabricating document; 468, using false document, a genuine document; 471 is also using document; 120B, conspiracy; and 34 in furtherance of common interest. But however, offence under section 420 was retained. By challenging that, the the father filed a revision in view of the victimology introduced in Cr.p.c. Then subsequently he seems to have died. Revision petitioner died. Therefore, the son filed an application to continue the revision. The High Court has rejected his contention, stating that there is no such provision to substitute the revision petitioner. Thereafter, he seems to have filed an application to recall the order. That was also rejected. Therefore, it went to Supreme Court. Supreme Court has given this ratio. They say, since rule of locus standi did not apply to revision proceedings on death of the revisionist, revision would not abate, more particularly when revision was not at instance of an accused. When a court is vested with discretionary power, discretion must be exercised judicially based on sound legal principles governing the scope of the power. Though the strict rule of locus may not apply for invocation of that power, court must be circumspect in entertaining petitions at the behest of complete strangers to dispute. Otherwise, discretionary power may become a tool at the hands of those who, though have suffered no injury, have an access to grind. Where revision is at instance of accused convict, revisional court may refuse to continue proceedings on his death. Where revision proceedings emanate from an order passed during trial, or revision proceedings against an order of conviction or affirmation of conviction, in a situation death of accused, trial would abate, and so ancillary proceedings emanating therefrom, the sentence or fine cannot be executed against the dead person. Therefore, in absence of any application from a person seeking leave to pursue the revision, the court may terminate the proceeding as having abated. However, where the revision is at the instance of impairment or a complainant on his death, the proceedings will not abate. That is ratio. Therefore, revisional court may exercise its discretion and proceed to test the correctness, legality or propriety of an order passed by the court subordinate to. There is no specific provision in Cr.p.c for substitution of a deceased revisionist. However, there is no provision for abatement as well as there is an appeal. That was also read. Hence, once revision is entertained, the court exercising revisional power has discretion to proceed with the revision and test the correctness, legality or propriety of the order under challenge before it, regardless of the death of the person who had invoked the revisional jurisdiction. However, while doing so, it is most important. The court may at its discretion allow a person to assist in discharge of statutory functions provided that person has no conflict of interest. When revisional powers are invoked by a victim of the crime and he dies during pendency of other victim of that crime who fall within the scope of the definition as provided under section 2WA of Cr.p.c, may be allowed to assist the court in effectively discharging its statutory function. Since revision is death, his son would inherit an interest in the property. The appellant is a victim of the crime and has vital interest in the outstanding of the proceeding. Hence, the revisional court could have allowed him to assist the court in capacity of a victim of crime. The order of the High Court dismissing the revision as having abated on death of the revisionist was held unsustainable in law, more so because the trial against the accused was pending. The order of rejecting application of appellant was set aside. This is ratio. I hope you understand. So, in precisely, I would like to share that if the revision is against the victim, revision is by the victim, where the accused respondents on his death, the revision may be continued at the instance of his next friend or the person within the definition of section 2 WA of the Code of Criminal Procedure. I hope you understand. Best wishes.